Separate legal entity principle. According to the case of Solomon against Solomon Company Limited, what happened in this case? Actually, in this case, Mr. Solomon ran a boot manufacturing business. And after that, the business became successful, and then he decided to incorporate a company under the name of Solomon and Company, in which he and his family were the only shareholders. Therefore, for the purpose of incorporations, he sold the business to the company. From the very beginning, he was the owner of the business. Then he decided to incorporate the company, and therefore he sold the business to the company after the company's incorporation. In return, the company pays Mr. Solomon in the form of shares, and the remaining balance of the sale price of the business, the company will pay by stages, meaning that Mr. Solomon have a share in the company, and the company also owe Mr. Solomon for the money amounting to £10,000. And for this purpose, the company charged its asset to Mr. Solomon. Therefore, in this case, Mr. Solomon was in two situations. Number one is he is one of the shareholders of the company, and number two is he was one of the company's creditors. The issues come into a picture when the company experienced financial difficulties. The value of the assets of the company insufficient to pay Mr. Solomon and the other creditors. Therefore, there are two legal issues involved in this case. Number one is whether Mr. Solomon was personally liable for the company's debt, since he was the founder of the company. Previously, the business owned by Mr. Solomon, he is the owner of the business. So whether he was personally liable for the debt incurred by the company. Number two is, if not, was he qualified to claim the debt from his own company? Because from the very beginning, we understand that the company owed Mr. Solomon for sale price, for the sale and purchase price for that business. Okay, in this case, the court held that Mr. Solomon got priority over the other creditors, even though he was the ex-shareholders of the company. Why? Because the company was a separate legal person. It has a right to sue and to be sued in its own name. This is when the company has been incorporated. Once the company has been incorporated, it will give birth to a new legal entity, meaning that the Solomon and Company is another person separately with Mr. Solomon. Therefore, a company is in other words, is an artificial person created by the law. And therefore, it is immaterial that the company bought over the business from its subscribers, and it is material that the Mr. Solomon has run the company as before. Since the debt were incurred by the company, the creditors could only claim for the repayment from the company and not its members. So therefore, Mr. Solomon was not personally liable for the debt incurred by the company, even though he is the owner of the business before, even though he is one of the shareholders, even though he was the director of the company. It will never make the members of the company liable. This is the doctrine of separate legal entity, as opposed to the partnership. Once the partnership business incurred some liability, got money owed to any other person, the director, the partner, will be personally liable for that. This differs from the company. The effects of treating the company as a separate legal entity. Actually, there are some effect for the incorporations of the company. Once the company has been incorporated, number one, a company can sue and be sued on its own name. Number two is the company have perpetual successions, meaning that notwithstanding that one of its members has passed away, the director passed away, the managers, the shareholders has passed away, but the company is still stand by its own. Furthermore, the companies can have a properties. The company can buy the properties, can own the properties under its own name. The company also can enter into a contract on its own name. And the last is the liabilities are its own and not of its participant or not its members.